And here to discuss this new Colorado indoctrination law is my former colleague and the former host of Case in Point, Sarah Parshall Perry, who has gone on to bigger and better things. I will tell you that, and don't let your head swell up, okay? Sarah is one of the smartest, most energetic lawyers I've ever worked with. If I was in a foxhole with bombs and bullets from the lawfare area being thrown at me, I would want you in there defending me.
That is high praise coming from you, because you have been in the belly of the beast and have taken your fair share of bullets in a foxhole.
So you're now the vice president, I think, and senior counsel, policy analyst at Defending Education, which tries to protect parents and students from indoctrination and propaganda in the schools, and to re-implement actually quality education. Gosh, what a concept! Right?
What a concept! We believe that American education should be value neutral and high quality, and unfortunately, right now it is neither. So we are very busy.
No, it's infused with politics. She has also testified numerous times in front of Congress. And you'll see her all the time on news websites, both TV, you can hear her on radio, and with a lot of op-eds. Anyway, Defending Education and a number of other organizations, you all literally have just filed a lawsuit against the state of Colorado over their version of the Ministry of Propaganda and Public Enlightenment, a reference from World War II that people might recognize. So tell us what this new law does, and tell us about the lawsuit that you all have filed against it.
Yeah, well, the state of Colorado, I think, believes that they are sort of operating a Manchurian candidate experiment in the state of Colorado, because they can't seem to get the balance between free speech and religious liberty versus anti-discrimination law twice. So they've just enacted a new law, and Governor Polis signed it going into the weekend. So I think he thought that no one would be paying attention to this. It's HB 1312, and HB 1312 is actually a modification of, it's an amendment to the pre-existing Colorado Anti-Discrimination Act, or CADA. Now, CADA, notably, has made 2 trips to the Supreme Court already. One in the Masterpiece Cake Shop series of cases with Jack Phillips, who simply wanted to be able to make wedding cakes using his artistic talent for heterosexual marriages in accordance with his religious beliefs, and one in last year's 303 Creative versus Alenis case, which was Lori Smith, the Christian website designer, who wanted to use her expressive medium and her free speech rights to communicate messages with which she agreed.
And in both cases, the Colorado Civil Rights Commission was basically persecuting them for that.
Absolutely, right? 100%. Both
and
individuals.
I use that word deliberately.
Yeah.
It wasn't a prosecution, it was a persecution.
That's exactly it. So both times, both were victors at the Supreme Court over the Colorado Human Rights Commission, but Colorado can't seem to get the message. So now what it's done is institute an amendment.
Is it they don't get the message, or is this them thumbing their nose at the Supreme Court and deliberately violating the First Amendment? I mean, it seems like, you can make a mistake once, but when you keep repeating it, that sounds like defiance of the U.S. Constitution and the court.
Well, that's exactly it. So what this amendment does is it actually requires in any place of public accommodation, and this is problematic because Colorado's definition of public accommodation is anything held open to the public. So it's not what we would consider from the 1960s, sort of the traditional public accommodations anti-discrimination laws, because these were related to common carriers like hotels or trains, restaurants, things that were held open to the public, but were also sort of the progenitors of services for the entire sort of specter of individuals. Right. Necessary services. But now we're looking at things like Christian website designers who are one-woman operations, or 3-person bakeries who are religiously held and really want to communicate certain messages. Now public accommodation is any public facing business. How does this impact the individuals that we brought suit on behalf of? It requires any individual in a public accommodation space, not operating a public accommodation, in that space to use mandatory preferred pronouns and selected names of individuals based on gender identity, even if those individuals disagree with the communication of a message that is antithetical to what they believe. It's the first time I have seen a state enact a law that is so patently unconstitutional that tries to concretize into the state canon a requirement to violate the First Amendment, because not every Coloradan is going to agree with the use of preferred pronouns or gender identity related names. In fact, Justice Amul Thapar, who's a good friend of Heritage Foundation, who's delivered lectures for us, actually wrote an opinion, a case called Merriweather versus Hartop in the Sixth Circuit about 5 years ago, in which he said pronouns communicate a message. They are a message of public importance. Well, our individual members, who are two of the plaintiffs in this organization's lawsuit, are individuals who are critical of gender theory, and they are trying to equip parents to fight back against gender identity. Well, you can imagine that they've previously violated what would have been an iteration of this law, because they've held events, conferences, they've recorded videos that go across public platforms in which they talk about a trans-identified runner as a biological male whose name, while he selects Ashlyn, might actually be Alan. So these individuals know that they've got a target on their back. They're effectively being muzzled. So we've brought suit, and we're the first one to the gate on this. I'm thrilled about it, against the individuals who are tasked with enforcement of the law in Colorado. Just yesterday, we filed a motion for preliminary injunction, so our fingers are crossed that we get a quick disposition and this law is put on hold while the underlying litigation proceeds.
Just so that folks kind of understand what this law does, when my kids were still home, we used to go to swim meets. They participated in my neighborhood's swim team. So they would ask parents to be volunteers, as the announcers, as the timer stuff. So if this was happening in Colorado and I was the announcer and I used the legal name of a boy who was basically pretending to be a girl and who was saying, well, my name's not really John, it's Juanita.
Right.
If I actually use his legal name, the Colorado Civil Rights Commission will come after me and can potentially impose a big fine on me,
Absolutely. Right? $5,000 per offense.
Oh, my God.
Mandatory re-education. Now, if that doesn't sound Manchurian candidate. Wow. And then there's a private right of action after the Colorado Human Rights Commission gets done with their process, administrative process. The individual then has a right of action, a private right of action, to be able to sue for violation of CADA. So this could be a very long, drawn-out process. And then we're talking attorney's fees, and we're talking monetary judgments, and potentially dignitary harm judgments. This could be very, very expensive. And understanding that our two parents themselves run organizations that are nonprofits, they could lose their tax-exempt status. All of their individual members are going to be muzzled. They hold conferences, events, they speak at churches, they speak at restaurants and rooms that they've rented out. These two individuals who are being very brave and coming forward and saying, listen, we're going to speak on behalf of other Coloradans who are absolutely feeling muzzled by this, in addition to an organization called Do No Harm, which is a series of gender-critical doctors, and Travis Morell, an individual physician who is in Colorado. Together, they all have reason to adhere to biological scientific fact, but Colorado has essentially said, you will bend the knee to gender ideology, even if we have to break the First Amendment to do it.
And basically deny plain science and plain biology.
100%.
I mean, that is just... Wait a minute. So I assume that this applies to schools, right?
It applies to schools as well.
So if I'm a biology teacher and I teach biology as in real biology, I could be persecuted by the Colorado Civil Rights Commission?
100%.
Oh, my gosh.
100%. So I have to tell you, Colorado is hostile to anything even resembling a conservative or traditionalist perspective on things like sex and gender identity. It is no place to speak your mind because you are now going to be faced with a very real possibility of persecution by the Human Rights Commission. Let me tell you how bad it was. And in fact, by the time it got out of the House committee into the Senate in Colorado, there was a provision that would remove custody from custodial parents if they dead named or misgendered their child. Now, by the grace of God...
Wait a minute. Explain. I'm up on modern crazy pop culture, but explain to people what dead naming means, which is now illegal in Colorado.
Yeah, that's exactly it. So
what is dead naming?
Dead naming is referring to someone by their stated original legal name, not their chosen name. So part of the sort of record on this in the Senate was debate over how important self-expression in terms of dress, name, and pronouns were.
Right.
But blissfully, I guess we have to thank God for little victories. The custodial provision was removed because there was such an outcry over this after it was passed, as is in the House. So that provision has been removed. But even for parents like Lori and Aaron, who are two members of our organization, they are staring down the barrel of a civil rights enforcement action and a $5,000 fine. They're having to go through right now and figure out, when did I say something that might come back to haunt me?
Right.
It's really an untenable situation to be in.
Did you file this in federal court or state court in Colorado?
Yeah, we filed it in the U.S. District Court for the District of Colorado. We are marginally hopeful, at the very least, we'll get the preliminary injunction granted. But regardless, we anticipate that this could be a very protracted series of sort of litigation moves, and we'll eventually find our way, I think, to the 10th Circuit. If we go back to the Supreme Court, you and I were talking about the show, I think we could expect an excoriating opinion from perhaps Thomas or Alito or Gorsuch indicating, listen, third time is not the charm for you guys at the Human Rights Commission. You have got, and I would not be surprised if at this point, CADA has become such a cudgel against Orthodox believers who simply don't toe the line on these progressive ideologies that are an iteration, we know, of sort of this neo-Marxist cultural movement, that they send them back to the drawing board altogether.
Now, I think I read a story that legislators who, in the state legislators who were behind this bill, were likening anyone who opposed them to being the same as the Ku Klux Klan.
Oh, yes. Yes, that came out as well. You have to laugh, Hans, because though it's so serious. It's so serious.
Right.
My heart breaks for the individuals in Colorado, and a lot of ministries, Focus on the Family, for example, is based in Colorado.
Right.
These organizations speak truth when it comes to their religious perspective and their belief that men and women are created. They are fixed sex at birth, and they are immutably designed by their creator with no error. No one's born in the wrong body. These individuals now, using public airwaves or speaking in public places, are going to have to muzzle themselves. The ripple effects, not just for our plaintiffs and not just for the organizations that are in this lawsuit with us, but for every Coloradan who disagrees with gender identity, is effectively to tape their mouth shut.
Yeah, and if I recall correctly from the prior cases you were talking about, like the Masterpiece Cake case, the individuals with the authority to come after you and persecute you, the people who are appointed to the Colorado Civil Rights Commission, they're not exactly reasonable individuals. I mean, they are extremists.
Oh, they're absolutely extremists. In fact, the first Masterpiece Cake Shop case, and there was 1 and 2, but the first time it went up, it was 2016, and the factual record developed at trial below indicated specifically that the Human Rights Commission members, when questioning him, had talked about the fact that he was a bigot and he was a homophobe and that his religious beliefs were backward. It was just this extensive extensive record of really patent targeting of religious beliefs. So he won, obviously, on the factual record the first time around, but then had to ultimately go back after he was still prevented from saying, my religious perspectives prohibit me from making a cake for your homosexual wedding. I will make a cake for anybody, for any event. But as relates to marriage, because I do believe it's a sacrament, I do believe it's between a man and a woman, that sent him back to the Supreme Court the second time. He's actually now in third time litigation, now with a transgender individual who is demanding a gender transition cake. So poor Jack Phillips, I mean, again, my heart goes out to him. Talk about a profile in courage. This is an individual who's gone, it is taking me the better part of 10 years and God knows how much money in fees and court costs and attorney's fees to be able to say, this is what I believe and I'm not going to bend.
Yeah, and look, for people who are watching this or listening to this who think, oh, well, there's nothing wrong with, for example, making someone who creates cakes, forcing them to do this. Look, think about it a different way. If someone came in from the Ku Klux Klan and said, well, I want you to make a cake we're celebrating the, 100th anniversary of Ku Klux Klan, do you really think a baker should be forced to do that?
Right.
Or, look, if just take it into political realm.
Yeah.
If you're a very strong Democrat, big supporter of Joe Biden, and someone comes in and says, well, we want to make a big cake, we're going to have a big Trump party, and should you be forced to do that, or the other way around?
Well, that's it.
And that is kind of what's going on here. Now, you mentioned that you're at the trial court level. Whatever happened is going to get appealed to the 10th Circuit, U.S. Court of Appeals. The courts of appeal around this country have very different atmospheres depending on what presidents appointed the majority of the judges. So is the 10th Circuit a friendly circuit or a hostile circuit to you? I mean, the Ninth Circuit of Court of Appeals, which I think even non-lawyers know about, which covers most of California, is a pretty hostile circuit to any kind of conservative issue. What's the 10th Circuit like?
10th Circuit is not much better, unfortunately. But we sort of anticipated that when we were filing this lawsuit because really, and at the preliminary injunction stage, I mean, the factors argue so clearly for immediate equitable relief because it's very clear that these individuals are literally in the course of their everyday work with these organizations, nonprofit organizations specifically, they are immediately going to be shut down. Mm-hmm. So all of the factors argue in favor of immediate injunctive relief, and I think we very easily satisfy that. So I would say even on appeal, I mean, to my mind, our Consovoy McCarthy attorneys are absolutely stellar, and it was a privilege to work with them and sort of the structuring of this litigation. But I think even the 10th Circuit is going to have to be forced to recognize the fact that these individuals are immediatally targeted and immediately muzzled.
I didn't realize you'd hired that law firm. Folks who don't know, the law firm they have for representing them in this suit is the very same law firm who fought the long, difficult battle against Harvard University and the University of North Carolina and got a terrific decision from the Supreme Court saying to those universities, no, you really can't discriminate on the basis of race in your college admission. So you definitely have somebody good representing you in that case.
And there was actually another attorney, Consovoy McCarthy attorney, who just won the procedural victory at the Supreme Court, the per curiam order that was reversing the censure against Representative Laurel Libby, who's the main representative who identified the trans athlete. And she was censured. She was prevented from voting. She was prevented from speaking on the House floor, specifically for a comment she made on social media. It went all the way to the Supreme Court, 7-2. Just Tuesday, we got a victory in that one, which was a restoration of her ability to actually vote and act like the assemblywoman that she is.
People should know the details of this. The state legislature in Maine was in session, and what was she talking about? Well, they were talking about the issue of boys who think they're girls participating in sports. And what did she talk about? A public event.
Right.
Right, a public track meet in which a boy had competed in the girls' sports and had won.
Yep.
And she's talking about a public event, and for that, she is censored and prevented from speaking on the floor of the state legislature. That is how far and extreme certain individuals in this country are willing to go to. They don't want debate about this. They want to chill speech and tell you cannot speak if you disagree with us.
Well,
that's what this is, right?
That's exactly what it is. And you know, it's so interesting because Janet Mills has obviously thrown down the gauntlet in her defiance to President Trump's face about the women's sports issue. And I thought very definitely the president she said, we're going to follow state and federal law. And he said, well, we are the federal law. And they are the federal law. And his interpretation of Title IX, for all intents and purposes, Title IX, the longstanding statute guaranteeing educational equality, sex equality in education, which also provides for equal athletic opportunity, has been restored to its original premise. Male and female are distinct and separate. And we're seeing Department of Justice take very seriously those states and those school districts that are defying their interpretation of federal law. So DOJ has launched an investigation into the state of Maine because of its refusal to acquiesce to sex-based distinctions in public education and continue to perpetuate trans-inclusive athletic policies. Governor Mills is out of step with 63% of Mainers, and Maine is not a conservative area. The First Circuit frequently gets things wrong. But I will tell you, I think this is just a perfect example of how the small, vocal, and well-funded minority is running the national narrative right now, and how grateful I am, I think, for the people who are standing up on the Hill and in the White House, particularly, in saying, wait a minute, we got to back up, and we have to restore the nation to common sense.
Yeah, and I think it's important for people to understand what you said about going back to the original understanding of Title IX. Title IX is the part of federal civil rights laws to protect women and girls, particularly in college sports and high school sports. And the whole reason it got passed was because, for example, big colleges were spending enormous amounts of money on all kinds of male sports.
Right.
And no money on women's sports. And the law came in and said, look, you can't discriminate against women that way. And now what are places like Maine doing? Once again, discriminating against women in sports by allowing men onto their teams and winning scholarships and winning awards that they shouldn't be doing.
Well, that's exactly it. Remember, Title IX was sort of a product of the women's liberation movement, right? The post-sexual revolution, and they fought for Title VII and employment equality, and they were good in getting it. They didn't get the Equal Rights Amendment, but they also did get Title IX of the Education Amendments of '72, and that provides an opportunity for everyone to go to graduate school, everyone to participate in athletic teams. And it didn't start out as the sports statute, but ironically, it was passed because a young woman in Connecticut in 1971 wanted to run on her boys' high school track team because there was no girls' team.
No girls' track team.
Right? And in response, a federal judge in Connecticut said, we need athletic character in our boys, but we don't need that kind of character in our girls. Well, that's all I would have to hear, right? So, but where are the feminists of old? They are nowhere to be found. This is the kind of regressive liberalism where at some point your victim classes become smaller and smaller and smaller and begin to overlap. So I guess the trans-identified population is now more important than the biologically female population, even though women's liberation movement activists were the one who gave us Title IX in the first place. So it's the height of irony.
Well, now everybody can see why I said you're one of the most energetic lawyers I know. And I will tell you, the folks in Colorado are very fortunate that you're pursuing this case for you. I wish you the best of luck, and thanks for coming here to talk about us. Now, something, Sarah, I've added since you left us, which makes me very sad, is I try to do a classic movie review at the end of Case in Point that's somehow relevant to the topic we were speaking about. So today, the classic movie review is the film version of George Orwell's book 1984, which, no coincidence, was actually made in 1984, and it stars John Hurt and Richard Burton in actually his last screen role. The movie was released shortly before he died. It is a very depressing movie. It's a very dark movie. But as you all know, the plot of this is about a low-level civil servant who lives in a country called Oceania, which has a thought police that wants to control everything you think, say, or do about politics, culture, and otherwise. And if you, in any way, do anything or say anything that is away from that political orthodoxy, you will be persecuted by the thought police. Doesn't that sound like what Colorado is doing now?
Yes.
I think it does. So this has been Case in Point, and court is adjourned.